you ready to check now?
Yes.
You're in the picture.
Okay, I'm going to call to order tonight's meeting, 7 p.m., August 26th. You there, Kim, to do roll
Yes.
call? Okay, roll call.
Okay, Mr. Urbowski,
Here.
Ms. Turner,
Present.
Mr. Eisner,
Here as I am.
Mr. Burris,
George, you're muted.
Mr. Burris,
Here.
Miss Rich,
Present.
Mr. Bolton. Oh, sorry. Mr. Smith, Mr. Smith, Miss Simon. Okay.
Okay, so I see we have some new members. Guess we'll give you a chance after we hear this item to introduce yourselves, and I guess we lost Mr. Bolton. We have two new members. Nice to meet you. So we'll get to that more formally when we get to board comments. So I'm going to call the application. Oh, wait, we have to do a quasi judicial announcement and swearing in of speakers. Do we have the legal counsel?
Robert Eschenfelder for the city attorneys, Mr. Chairman.
Thank you.
You're ready to proceed with that?
Yes, please.
Okay. So this is the Board of Adjustments quasi judicial procedures that I will read for all the audience and participants. This is a quasi judicial proceeding where the Board of Adjustment acts in a quasi judicial rather than a legislative capacity. As a quasi judicial hearing, it is not the Board of Adjustment's function to make law, but rather to apply law that has already been established. In a quasi judicial hearing, the Board of Adjustment is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The Board of Adjustment may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the Board of Adjustment is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the Board of Adjustment is required by law to find against the applicant. There is an established procedure which will be followed at the quasi-judicial hearing and as controlled by the chair. All witnesses must give their testimony under oath. All persons testifying at the hearing must give their name and address for the record. All testimony and questioning at this hearing must address matters that are relevant and material to the issues under consideration. The city staff will present its testimony and evidence first. The applicant will then have an opportunity to cross-examine the city staff. The applicant will then present its testimony and witnesses. The city staff will have an opportunity to cross-examine the applicant's witnesses. Members of the public opposing the application will then be given an opportunity to present testimony. After all members of the public speaking in opposition to the application have concluded, members of the public in support of the application will have an opportunity to present testimony. The applicant will then have an opportunity to make a closing argument or summary, after which the city staff will be given an opportunity to make a closing argument or summary. Following this, the Board of Adjustment will consider the matter. The Board of Adjustment members may ask questions of witnesses at this point in the proceedings or at earlier points where the chair authorizes. A motion will be made and a vote will be taken to dispose of the application. At this point, I will swear in all witnesses who intend to offer testimony at this hearing. So if everyone who is going to provide testimony, whether you're the applicant or city staff or citizens, if you would please raise your right hand. Do you swear or affirm that the testimony that you are about to give in this proceeding is the truth, the whole truth, and nothing but the truth? If you say I do.
I do.
I do.
Okay, thank you. And if anyone does decide to testify who has not already been sworn in, if you could alert the chair to that fact, and I will swear you in at that time. Mr. Chair, is back to you.
Okay, so going to application 20-82, variance to reduce the side setbacks, location 184 North Spring Boulevard. So to the city staff.
Yes,
What do you got?
this is Pat McNeese, Principal Planner, and I'm going to be sharing my screen.
What?
Sharing my screen, hold on. Okay, can
Oh.
you see that?
Got it.
Okay, good.
Okay.
All right. So again, Pat McNeese, Principal Planner. This is a request to authorize a dock and boat lift, covered boat lift that does not meet the basically the dimensional criteria in the city's code. So this is located at 184 North Spring Boulevard. And our code requires the docks, the walkways and the docks to be in the center 1/3 of the waterfront width of the property. And it restricts the length of a dock to half of the width of the waterfront property. So this property is located here along Spring Bayou. This picture shows a previous dock that has been demolished, and the applicant would like to replace that. This is the property survey that was submitted by the applicant. Again, shows that previous dock that was apparently there when the survey was done. This dock exceeds, the proposed dock exceeds both the length requirement and it encroaches beyond the center 1/3 of the riparian lines of the property. So if you look at the width of the property is about 35 feet. If you follow those riparian lines out, the proposed dock will be violating that center 1/3. This is just a layout of the dock submission by the applicant to the city. And this shows just a kind of a sketch that staff tried to put together of the approximate center 1/3 in those green lines and the approximate area that this proposed dock would take up. If the application was in compliance with the code, the allowable length would be about 17.5 feet. And the width about 5 or 6 feet. As you can see, because of the lift and the terminal platform, there is a wider area at the end of the dock than would be allowed. The applicant could go ahead and get this permitted if the adjacent owners on either side were to sign off. The applicant was able to get a sign off from the northern neighbor, who is actually the most affected by this layout, but was not able to get a sign off from the southern adjacent neighbor. Again, this is an oddly shaped lot. The circumstances were not created by the applicant. The frontage of the lot is somewhat curved and it's very small. This is just a sketch of the elevation of the proposed dock. So hitting on your review criteria, again, this hardship from the physical condition or shape of the lot that is unique to this property. That hardship is not self-created. With respect to number 3, staff feels that the applicant could construct a dock of some sort that would comply with the code, and therefore that this did not rise to deprivation of reasonable use in this case. So that was one that we felt was not met. Since the staff report was submitted and provided to you, the applicant has submitted additional information, which was sent this morning. I do have that available if we need that, regarding water depths. On that, and the applicant will, I'm sure, present and talk about that. With respect to water depth, the city does not have any standards. The county does have standards. Once the city approves a dock based on its basically 2-dimensional criteria, which is all we really have in our code, then the permit goes to the county for review. If the county requires a longer dock to meet a water depth requirement, then that would be a physical hardship. That has not been presented to date. But the applicant has presented their own evidence with respect to number 4. Granting the variance would not confer a special privilege. There are other docks in Spring Bayou and this is a normal accessory use for these homes. And number 5, staff doesn't feel that
Mark, is there interference?
staff doesn't,
Simon is on the phone.
okay. Staff does not feel that the approval of this dock would injure or diminish property values in the area. There are other docks, similar docks, larger docks in the area. The property owner most affected, as I mentioned, is the one to the north, and that owner has signed off. The property owner to the south has not signed off. They have about 118 feet of waterfront width, and we do not believe that this would diminish their enjoyment of the water or their property value. This application was noticed, and we received, since the staff report, we have received one written response, which if that, I don't know if that person is here. It was from the from the southern neighbor. So they may be here to testify, or the email can be read into the record by Kim. And staff is recommending denial of this variance for relief from the dock length and dock centering criteria based on our evaluation that it does not meet all 5 of your criteria. Are there any questions?
Yes, I do.
Go ahead, Mr. Eisner.
Do the dock builders, not the dock builders, the owners, do they need to have the signature of the south and north residents in order to move forward?
If they have the signature of the south and north residents, they could move forward without the variance. We would have approved the permit. And I should have mentioned, I did fail to mention that this dock did go to the Heritage Preservation Board for review, and the applicant did receive a certificate of approval for this dock design and size and layout. So that box has been checked here.
So if both signed, this would not be before our board, is what I'm understanding?
That's right.
That's correct.
Okay. When we either agree or disagree with the variance, do we have to agree on a boat cover, or are we just doing this on the dock?
The 2 criteria that are before you are with respect to the position of the dock along the width of his property and the length of the dock only, not the design of the dock. And
So he can decide, or they can decide to build this boat cover or not?
yes, I mean, the Heritage Preservation Board did approve the boat cover, so it would have to be built as approved by HPB, but they don't have to put the cover on if they don't want to.
I misunderstood. I didn't hear you through the Zoom. Did you say that the other, they agreed to it or they didn't agree to it?
They did agree to it. So the design that you saw in the picture in the slideshow, and I can put that back up if needed,
No,
that was approved by Heritage Preservation Board. Now, if they choose not to build the cover, they don't have to. They can't do a different design. Do you see what I mean?
yes, what I'm trying to get to the point is we're not making a decision today as a board. about whether they can have a boat cover or not. Our main decision is where this dock is to be placed, correct?
That's correct.
Okay. That answered my question.
Ms. Turner, Jackie?
Thank you. So following up on Mr. Eisner's clarification, we are deciding position as opposed in reference to the 1/3, the center 1/3. So position relative to the 1/3,
Correct.
length and width. Or not width, because width is irrelevant. It's more of does the width impact?
The width as proposed is encroaching on the center 1/3. So
Okay. And can you please clarify, I was trying to read through the packet and I apologize if I've missed it. What is the proposed length and width that the applicant is requesting?
the proposed length, and probably should have been just spelled out in the staff report.
It's about 28 feet. just
20, yeah, about 28 and a
and
half
a
feet.
couple of inches. And at the
Okay.
biggest part, it's 12 wide.
Yeah, and that is illustrated in your packet
Correct.
on the Ameridocs drawing.
And I don't want to fall out of turn on this, so council can tell me to hold off if this needs to be addressed at a different point. But is this a time to continue asking Ms. McNeese questions, or do we want to hold that for another point?
The chair basically controls his board. And so if the chair allows members to ask questions at this time, that's perfectly fine. I mean, under the
Chairman?
under the order of procedure, everybody goes and then the members ask their questions at the end. But as long as the chair authorizes members to ask questions contemporaneous with the presentations, legally, there's nothing wrong with that.
Thank you.
Right, and that's how we conducted it before they changed to this process. We were doing it that way first, but either way is fine. But since
That's good with me.
right, but Patricia asked any questions, thought let's go with it.
Yeah.
I lost you for a minute, Jackie. You were saying something?
No, I just wanted to say, what direction did you want to go? Do we want to keep asking Ms. McNeese questions or hold that?
Gotcha. Okay,
Very
that part I
quick.
didn't hear. I see Mr. Burris has a question.
Yes, for Ms. McNeese, you mentioned that if the applicant gets approved tonight, it has to go to the county. And if the county approves, it changes the criteria. Did I understand it correctly?
If the county approves, he can build the dock. If you approve it and then the county approves it, he can build the dock as designed.
Then it's like putting the cart in front of the horse. That's okay. We'll discuss it later.
Okay, so I guess we're going to move on to the presentation from the applicant. Mr. and Mrs. Kutchman,
Hello.
Hello.
hello. This is your time to give us your presentation.
Hello, and thank you very much for the time. I really appreciate all of your time. I hope that everyone got all the information that we submitted, all the pictures and the video. We feel that the dock is not large or inappropriate or any way encroaching upon our neighbor's sightline based on those pictures and the video. As Pat pointed out, our southernmost neighbor who signed off on it would actually be the one that would be the most impacted, and they didn't have a problem with it. We have been trying unsuccessfully for over 6 months to get the southern neighbor to give us a yes or a no.
And if I can interrupt you just for a moment, I'm sorry. Could you state your names both out loud for the record and that you've been sworn, please?
Certainly. My name is Kara Lynn DiRocco Kutchman. And yes, I was sworn in.
Thank you.
I'm Derek Kutchman, and yes, I was sworn in.
Thank you so much. Proceed.
I just basically want to say that, when we purchased the house about a year ago, the existing dock was an eyesore, a danger, and in violation. And we did have it removed. And we're really, I feel, not asking for anything unusual based on the other docks that are up on the bayou. And certainly we would never want to encroach or infringe on anyone's view. But as demonstrated in the pictures in the video, we really feel that we're still in our property, but we're just going over a little bit outside of that middle. And we really don't feel that we're hurting anyone's view.
So I would also like to add that, I mean, just to fit, we feel like this is kind of an average size dock. I'm actually looking out the window right now at all the other ones. The dock we're building is the same size or less than those. And just because of the constraints and the strange angle of our property there and how it's a pie shaped, we can't really fit anything in there. So that, I mean, we're just trying to build a standard dock just like the rest of the neighbors here have, just to lift our boat and enjoy the bayou as everyone else does. And we've repeatedly tried to get the neighbors to sign off on it. I don't know if you've been able to read through the packet. There's some pretty extensive information that I provided yesterday about how they've been handling us, and it doesn't seem very fair to us. And we're just trying to utilize this board to hopefully see our point of view here and support us.
Okay, does that complete your presentation?
There'll be a moment at the end for us to have any kind of rebuttal after the board speaks. Yes.
That's correct, because we're going to also go now to public comment.
Okay.
Yes. Mark, we have raised hands.
If anyone would like to speak at this point, please raise your hand.
Going to do affected parties. Oh, I'm sorry, Kim. Did you want to read the email?
Well, I need to know, do you want to hear the email or the Mr. Shannon speak? Because he's the one with the raised hand, or both? Both?
I guess, let's do both.
Okay. Then I will read the letter if that's okay. If you'd like to hear from him first, we can do that.
Well, that's great. Where is this gentleman? Is he on?
Yes, he is. I'll allow him to talk.
Yes, please. Let's just go there. Sir?
Hello.
Yes.
Yeah, this is Jeff Shannon, and yes, I was sworn in.
Okay.
I'm here on behalf of Wake Real Estate Holdings,
Yes.
and really, I'm just here to support what was stated in the for the record in my recent email from last Friday.
Yes. Would you like us to read that into the record?
Could we read that into the record first, and then I'm happy to comment on it.
Absolutely. Yes. Kim?
Thank you.
Okay. It says, to members of the Board of Adjustment, City of Tarpon Springs, Florida. Patricia McNeese, Principal Planner. Kimberly Yothers, Secretary to the Board. From Jeffrey C. Shannon, as the manager of Wake Forest Real Estate Holdings, LLC. Wake Forest, LLC. Owner of the property, the Wake Forest property, located at 170.5 North Spring Boulevard, Tarpon Springs, Florida, which adjoins the property, the Kuchman property, located at 184 North, to which the new dock will be affixed. Application 2082, the application, 184 North Spring Boulevard, Derek and Kara Kuchman, requested variance to construct adjacent to the Kuchman property, a single family residential dock with a covered boat lift, the new dock, that exceeds the maximum allowable length and is located outside of the center 1/3 of the extended property lines at the waterfront. As the manager of Wake Forest LLC, I am in receipt of the public notice of the requested variance from the Board of Adjustment, and additionally, I request from the Kuchmans to execute a joinder to a variance request form, the variance request form, which joinder to a variance request form requested the Wake Forest certify as to the ownership of the Wake Forest property. Acknowledge the Wake Forest LLC has reviewed the plans for the new dock and memorialized whether Wake Forest LLC objects or does not object to the new dock. At the time, Wake Forest LLC did not respond to the request to execute the joinder to a variance request form because it appeared to be pre-populated with the box next to "Do not object" already checked. As a result, if Wake Forest LLC was to have checked the alternative box for do object, its response may have been at a minimum confusing to the Board of Adjustment, or worse, disregarded because both boxes were checked and Wake Forest LLC's intentions could not be confirmed. In anticipation of the upcoming Board of Adjustment August 26, 2020 regular meeting at which the application will be heard, Wake Forest desires to clarify and memorialize the following with respect to the application. Wake Forest LLC is actually the most severely affected property owner, as A, the boundaries of the Wake Forest property are the closest to the boundary of the Cushman property where the new dock will be located. B, Wake Forest LLC is the property owner next to the area of most impact, which is the covered boat lift. And C, the new dock, if situated at the proposed location, would be almost directly in front of and partially block, particularly with the covered boat lift, the water view from the Wake Forest property. The new dock could injure or impact Wake Forest's rights and substantially negatively impact Wake Forest property. And Wake Forest hereby does object to the new dock, and as a result, the requested variance and further requests that a new dock should not be allowed by the Board of Adjustments to be constructed, and B, the requested variance should be unequivocally denied. Should you have any questions regarding Wake Forest LLC's response to the requested variance, please contact me. A copy of this correspondence is being contemporaneously delivered to the Board of Adjustment offices via FedEx. Thank you for your attention. Jeffrey Shannon, manager of Wake Forest Real Estate Holdings, LLC. Jeffrey Shannon, PA, 2025 East 7th Ave, Tampa, Florida, 33605, 813-906-6450, extension 2. J. Shannon at jcshannonpa.com.
Thank you. Mr. Shannon, do you have anything further to add?
Just 2 quick points. One is that Wake Forest, when it bought its property, was faced with similar issues in terms of its waterfront. And just as every lot owner along the bayou has been faced with those issues and has to address those issues in conformance with the code and with the boundaries of the property that is purchased. So I would just offer that up as that the applicants have purchased a piece of property. They were aware of the boundaries of their property and the constraints on the construction of a dock as a result, and must live with that as everyone else on the bayou. And the second thing is that this board will determine the position length and width of the dock, and it appears from the drawings that the width and length, because of the width and length, far exceed the setbacks that are provided given the dimensions and boundaries of the Cushman's lot. And that is where the problem really lies for the southern property owner. Thank you.
Thank you, sir. And hang on a moment. Does the board have any questions for Mr. Shannon at this point?
Question, yes.
Mr. Eisner.
In your first statement, you had this would be almost directly in front of. How did you come up with that?
That I was more concerned, and as you know, and let me explain too, as an affected property owner, the reasons for why the property owner doesn't object really are irrelevant. The purpose of this exercise is to determine whether the property owner that is affected objects or doesn't object. But I went a little further just to explain that we believe, again, you can't visualize without the dock there, but there would be impact to the sight lines from our property.
Well,
and that was the reason for that statement.
Well, I'm not looking to provide evidence because that's not my job to do. But with all of the information that was provided to me, I usually go to the site to see if that is true. And when I was there today, I kind of couldn't understand where that comment was justified in saying, because you can't actually see it whether the dock is there or not. That property is nowhere near the dock. So that's why I'm needing you to clarify if something is impacting, as you said here, almost directly in front of, you have to be 60, 70, maybe 80 feet away from, if I was to stand by the property that you're representing, I probably couldn't even see the dock. The dock would be the only thing blocking is another house, not the Spring Bayou at all. So I don't understand where you have the, I'm just shocked to hear that you can make a statement like that.
And again, without the dock there, without the visual or the optic, it's impossible to know for sure. And so I was making a statement just to say that in support of the non-objection. But again, the point is, I could have just written an email that just says the affected property owner objects, and that would have been,
yes.
I was trying to point out that there might be an issue with this sight line. That's to be determined.
So my other question to you is, how would you present to us that this could injure or impact Wake Forest's, substantially negatively impact Wake Forest property, since it's nowhere near it?
Because of the fact that it will extend beyond the setbacks that are provided for the dock, which means it further impacts what Wake Forest is ultimately able to do with its waterfront, because those setbacks are in place for a reason. And that's what the code enforces, and that's what your board enforces. And so that's to protect property owners' rights. And because of the fact that those setbacks would be affected by this decision, our rights could be affected as a result, depending upon what that decision is.
That may be true. The only problem that I look at is many docks in Tarpon Springs over the years have had to be extended out for silt and depth of water. So there is extenuating circumstances that come about that you can't, there's nothing you can do. Just off the beaten path for a second, we've had situations where somebody has to move a dock out to a point where when it's coming out to 2 points, they would almost be off their property line if they had to go out far enough to be able to make a dock that a boat could pull up to. So regardless of what our rules and regulations are in our guidelines, that's why we make decisions on depth of water more so than we do on appearance. When you buy a house on a water and you don't own everything around you, other people have to live as well and have use of what they've purchased. So I just don't see how it's impacting your particular property. So.
Okay, anybody else on the board? Yes, Ms. Turner.
Thank you. And thank you, Mr. Shannon, for joining us tonight. I do have a few questions in regards to your verbal presentation this evening and the historical emails that was provided to the city. So you had referenced that Wake Forest in your verbal had said that they had some issues with their own dock construction and everything when they had purchased their property. So they're referencing their dock experience. However, that was never noted in any of the communication between you and the applicant. However, there was quite a bit of information about a tree that had fallen and was not addressed by the previous property owners of the applicant property. So in fact, an email on May 13th between yourself as representing Wake Forest and the applicant saying that they may want to offer them money for the damage. It may help move our variance request along. So it seems that this tree situation seems to be more of a concern maybe than a view or issues they may have had with their own dock. And the second point I wanted to address was in the email that Ms. Yothers had read for the record, which was submitted on Friday afternoon, what is that, the August 26th, saying that there was an issue with the check boxes of object and do not object. However, it seems from the historical records of the conversations that the applicants first attempted to reach the Wake Forest on February 23rd, and the applicants were successful in making sure they had this form, the variance request form, on March 13th. So I'm just questioning why it took from March 13th to August 26th for them to bring up the issue with the checkbox on this form.
Let me take your first question first. As I indicated previously, and as I think your legal counsel would advise, the fact that an affected property owner has other issues or has no issues with a neighboring or contiguous property owner is really immaterial. The fact that those issues were presented to the Cushmans as, hey, can we resolve these at the same time, is really irrelevant to these proceedings. Because again, the property owner can object for any reason. And then secondly, boxes, there was not really an opportunity to discuss the boxes before then. There was just a request for a do not object to be submitted. And so when the opportunity came along in anticipation of the hearing to submit some written confirmation of Wake Forest position, that's when that opportunity arose and was taken advantage of in terms of the statement that was made. So it's simple as that. A lot's happened in the last 4 or 5 months in terms of the world at large and COVID. So everybody's been busy with other things, and quite possibly this just wasn't as much of a priority as it should have been.
Any further questions, Ms. Turner?
No, I mean, I'm just, I realize that, we do have COVID. We've all been working through that. The 5 months to address it does seem excessive when somewhere in the middle of that, the remark of we could maybe settle this by, taking care of the tree situation for a few $1,000s, that there was the ability to do that. So I was just a bit perplexed. So thank you for clarifying those points.
Mr. Boris, you have anything?
Yes, I have anything. To follow up on the question that was just asked about the 23rd of May, on the 25th of August, that's the last line where it's highlighted with the yellow marker. The same issue comes up as far as the money and whether to pay the damages and so on and so forth. You have a house on North Bayou, and you have such a small place in the front of it to put a dock. Very shallow. The length of this dock is going to be 28 feet. The width, I assume, it's going to be about 28 to 30. We don't have the information on the enclosed area. We only have the information on the deck. But let's assume it's 28 to 30 feet, which is very close to the property line on both sides. As Mr. Eisner mentioned earlier, there's no problem with visibility or anything like that. I just can't see the point taking this from March to the end of May to say no. I have the same questions also. Thank you.
Ms. Rich.
Thank you. Just a question that was spurned during Michael Eisner's questioning. The comment about, once it comes through us, it then goes to the county. And he was talking about some of the longer docks that are needed in the area. If the motion to have a variance was denied tonight, if it was denied, then is it just then a mute if they're able to do the standard size dock that would not require a variance, as staff member Patricia McNeese mentioned, if the county determined that it would need to be longer because of the title issues, would it have to come back to us for a variance due to length at the homeowner's expense, or would it be an automatic approval of the length due to the county's?
They would only get that, Joanne, my understanding, but please, Patricia, or the attorney can chime in, but they can only get that if both neighbors signed off, which they are not. So if we deny it,
No, I'm talking about if they did,
Seconded.
if they did the dock that similar to what was there, that did not require a variance. But
Yes.
then the county said it needed to be longer due to title issues. Would it have to come back to us, or would would the length be okay if the county said it had to be longer?
Yes, so
So-
if the length, if the dock was proposed and turned into for a building permit compliant with our code, went to the county said, no, it's got to be longer. It no longer complies with our code. It would have to come back to you, and that would be a physical hardship that petitions and staff would present and evaluate for your consideration.
Thank you.
Jackie, did you have something else?
I did.
Mike?
This is a question on May 1st. There's an email in front of me that says we received a voicemail from Mr. Shannon describing a situation with the owner of the property at 170 and a half North Spring Boulevard, having an issue with the prior owners of our home. He stated there was a storm that had blown down a tree that was on our property and landed on the neighbor's property, damaging a section of the fence between the 2 yards. This took place before we purchased our home. We are unaware of the situation until it was revealed in this voicemail. Mr. Shannon stated that the owners of the property at 170 and a half Spring Boulevard had paid for the tree to be removed and the fence repairs, but had not collected any money from the previous owners of our home and were not willing to give us an answer regarding the variance form until they had time to figure out what they wanted to do about the money owed to them by the previous owners for the tree removal and fence repair. So I have to ask before I ask my next question.
Mr. Eisner, let me just go to Robert. We're not to consider any of this, or are we? Before we keep asking questions of Mr. Shannon about some tree, is that for us to consider at all?
The objection that the neighboring owner has cited is sight lines, which is a valid concern. The fact that the representative of the owner appears to have offered a quid pro quo of, if you pay us money for the damage to the fallen tree, our objection will disappear. That will simply go to whether the members believe that the stated objection, which is the sight lines, is offered in good faith or is just made up as a valid reason when the real reason is a desire for money.
So you got that, Mr. Eisner? Move on.
I do, but I need to ask the question, was that actually the response that Mr. Shannon gave?
Mr. Shannon.
I'm sorry, Mr. Eisner, can you repeat the question? Was the response?
Well, it states here on May 1st that you had stated to the owners of the property that you represent that they paid for the tree removal and the fence repairs, but had not collected any money from the previous owners of the home. Is that something that you presented to the new homeowners?
What I probably said is that we have a lingering issue that should be addressed, and that there is an objection to the dock, but it would certainly help in terms of consideration of that objection if this lingering issue from the closing of whenever they acquired the property was resolved.
Did you also suggest that we may want to offer them money for the damage and it may help move our variance request forward for the $3,000 to $5,000 range? Was that another request?
It was all in the context that I just spoke of.
Okay.
That there was this past issue, weren't aware what the Cushmans knew about it from their closing, really unrelated to the objection, but there clearly was going to be an objection to the dock. But it would certainly, as you know, people do when they're dealing with one another, if they resolve one issue, then maybe it helps resolve another. It was something that it was under discussion at the time.
Yes, I agree. Okay,
So
thank
at
you.
this point, the Cushmans, I believe, can cross-examine the affected party, Mr. Shannon. Do you have something to say?
I do. Thank you. This is Kara. Mr. Shannon, you said last night, actually, when you called us, it was on speakerphone with my husband and I, that again, you just wanted to be the intermediary, your words, and that you were just acting on behalf of your client, that we could get this process moving right along if we could just come up with some kind of payment and then the variance would be granted. But earlier you said that statement that you made was irrelevant. So if it was irrelevant, then why ask for payment in May and then do a Hail Mary last night and ask for payment again so you could, quote, move the process along?
As I just explained to Mr. Eisner, it was a lingering issue from before. I thought it might relieve the logjam of having an objection to your dock. So I suggested it again, as simple as that.
Well, I just want to say, sir, that
that's why,
it's,
and let's clarify, that's why I thought it was irrelevant because it has nothing to do with these proceedings, but it was a lingering issue for the adjacent property owner. And I thought, hey, if we can resolve that, maybe we can make some progress on the objection or talk about what the objections truly mean and what the proceedings today would decide.
you had made a very valid point that they still had a very sour taste in their mouth from not receiving payment from the previous owner. Then, you know, we could just make this go away and they would sign off if we just paid something. But we weren't aware that a tree had gone down or there was any damage, as it had happened years prior to us purchasing this home. So you're right, it is irrelevant, but the fact that they're still sore about it has nothing to do with their sightline or their property.
And ma'am, if I could, at this phase, it is cross-examining. And so you'll have an opportunity to make a closing statement and make those final points. But here you need to just pose questions to the opponent.
I'm sorry, I didn't mean to speak out of line.
That's okay.
I have a question.
Hang on
Mr.
one second.
Shannon?
Do the Cushmans have any further questions of Mr. Shannon?
I believe he said everything to us and we understand what he was saying.
Yep.
Understood. Okay, Mr. Boris.
Yes, Mr. Shannon, I am a mechanic by trade. And if I repair your neighbor's car and I said to your neighbor that he needs brakes soon, and you buy that car, you bring it back to me and you say, why didn't you fix the brakes before I bought the car? Is that what you're trying to do here with this $3,000 to $5,000 deal with the tree? In other words, you started back in March, you continue in May, and then at the end of August, the night before, you're still asking for the $3,000 to $5,000 bill. It doesn't make sense.
Do you have any reply, Mr. Shannon? Because we're going to move on to another public comment if not.
Yeah, that's fine. Yes, and my comment would be again that it's an unrelated matter. I just thought if it could get resolved, it might help in the dealings with the objection, because the objection was so adamant on behalf of Wake Forest that I felt like I thought that maybe part of the reason for that was this lingering issue from a year ago that should have been brought up at the Cushman's closing and apparently wasn't. So that's why. It was not a direct tie. It was to resolve that issue so that this objection could be removed potentially, or at least negotiated. So, and again, the objection doesn't require any explanation. It's just an objection to the variance or to the new dock. So that's it. Thank you.
Thank you very much. So we're going to move on to the next public comment. Do we have another affected party, or is this general public? Mark, do we have someone else?
We do not have any other raised hands at this time.
Okay, so I guess at this point, we're moving for your closing statements.
If I could, Mr. Chair, although I doubt that they do, I don't recall us offering the Cushmans the opportunity to cross-examine city staff.
Oh, sure. Yes, very.
So
very
if you do have any questions of Ms. McNeese, now would be the time to ask them. Otherwise, then you can move on to your closing statement.
Yeah, no, we don't have any questions.
I believe that we've presented everything via videos and pictures and measuring of the distance and the length of time that we've been requiring a signature. So I think we've presented everything as best we can.
Oh, there's one thing I'd like to add. On the 14th of May, I gave Mr. Shannon the prior owner's phone number from what I had from our closing documents. I gave him the real estate agent's information. I gave him the title agent's information in hopes that they could reach out to them and deal with that whole situation. I never heard what they did with it, but I gave all that information to him on May 14th. So.
And I do want to just add that Mr. Shannon said that, we should have known this at closing. That was not presented at closing. So, but that again, wouldn't have anything to do with us. That would have had to do with the sellers of the property, and that would have come out of their closing monies. So I don't understand why it's coming up.
So now we're going to have questions from the board to the Cushmans. Mr. Eisner?
I have no questions.
How about you, Jackie?
Not of the Cushmans, but I did have a question of staff when we are ready.
Okay, hang on, Mr. Boris.
Yes, I have a question for the Cushmans. Do you have anything on an email on this tree deal other than the phone calls?
Yes, we have. It was submitted, the email that.
What are you asking? I didn't understand the question.
He asked if we had anything that Mr. Shannon had said about the tree in an email.
Yeah, there's one email.
There is one email that I believe that was back in May. Was it in May? It was submitted in the packet that you have.
Yes.
Mr. Boris, we got an addendum today. Perhaps you didn't see it. It was an additional packet of emails. Additional backup material.
I only saw the letter. That's fine. Okay.
Yeah.
There is an email from Mr. Shannon talking about what we've just discussed. Yes.
With monetary numbers and what we could do to make this go away.
And it's part of the packet. It's in there.
Thank you.
Any questions?
Of who to who?
Joanne. Do you hear me, Joanne?
No questions.
Thank you. I have a question for the Cushmans. So the city is saying that they believe you could build within a certain footprint, and you're saying you need to build it bigger. Please explain.
No, you go ahead. Certainly, as the chart lays out and it's demonstrated, it's an unusual shape and form. And due to the tide, I measured yesterday with a yardstick, if you will, or whatever, but we also have the tidal charts in there. And based on the dock builders and the shape of the lot, that was what the recommendation is. Also, the fact that we are not encroaching on other people's properties, it's just outside of that middle. That is basically what is saying. Please, I don't know if I explained it.
Well, no, and the middle third of our property is, and because of the shape of it, the pie shape, it becomes so thin down there that without some variance, we can't fit a boat and out there so that we can enjoy the water. So it's just kind of naturally become what it is right here, right now.
Understood. So Patricia?
Yes.
Having just heard what they said, how could they possibly put something within the footprint that you were suggesting?
Again, when we evaluated this project, we did not have the information that they've now submitted on water depth.
Yeah, the water,
I
understood.
sent you a packet yesterday. I would
Yes.
like to confirm that the board also received an email that I sent this afternoon that the Cushman supplied. It is an email from their dock builder. Now, to my knowledge, he or she is not here to testify directly, but I wanted to confirm that the board received that email. And if you didn't, we're available to read that if you.
Yes, I got to see it. Does anyone else need to see that before they vote tonight?
No,
No,
No, but I did have a question regarding
Please.
that email for
Yes.
Ms. McNeese. In reference to that email and your synopsis of the application, which by the way, thank you. I think it's a great format for us in this virtual world. The PowerPoint that you put together, the blue. So thank you. So given this new information that you were provided by the dock builders, and tell me if you're not at liberty to answer this, would number 3, would that impact or change the staff recommendation?
good question.
Yeah, again, staff, because there is no city standard for depth, technically speaking, staff would have to rely on the county's evaluation of the proposal and whether it meets the depth code.
Okay.
We would not be able to make a decision and grant a variance basically at staff level based on depth information supplied, just
By a non-county
applicant.
entity. So
Yeah,
that brings back what Ms. Rich was saying earlier. Say if we were to deny the variance today, but the applicants could then present this information to the county with the proper depth analysis and so on. If they said, no, this needs to go here, then what's the next step for the applicant?
I will add, however, that I'm not being intimately familiar with the county's criteria. They, the knowledge I do have tells me that they will look at this from the standpoint of protection of their resources, right? The bay bottom, seagrass, not protection of the owner's boat. I'm not sure of that, but this evidence that was presented that the applicant has submitted is telling them that is saying that the boat may be damaged because it will be sitting on the bottom at times. I don't know that the county uses that as a sole criteria. So it depends on the conditions at the dock, the bottom, the seawall, whatever the criteria they use. But they're going to look at their perspective. And
Thank you very much for that clarification.
Okay.
I
So it's
have a
looking
question.
more and more like we're meeting these criteria. What do you got, Mr. Burris?
Okay, if the county comes back and says it's not far enough and it has to go further, will it come back to us or the city has to approve it?
No, the Cushmans could then come back to you, and that would be an additional hardship that they would present. But the board would have to grant the variance, assuming that.
Okay.
So the county's decision is supreme here. In other words, everybody depends on it. Isn't that correct?
It is, Mr. Burris, but let me also add that they've got a builder who knows what they're doing, assume, right? That they know they've dealt with the county. So they're already going to think ahead of what they're going to say. So they don't have to go twice, right? That's probably why it's already the way it is. That's my assumption, but please.
Well, that's fine. I'll take that.
You understand what I'm saying?
That's
How
fine.
about you, Mike?
This is just I'm a knowledgeable boater. You cannot launch a boat in dead low tide that close to the dock. It has to be out from the bulkhead a certain distance. That's why all of them are like that around the Spring Bayou. It's not so much anything other than that. That's exactly the whole reason why they have to be somewhat of it a ways out. Otherwise, they would only be able to launch at certain tides. And we do have unorthodox tides here.
Okay, if we have nothing more, we're going to go for a motion.
Motion to approve?
I second it.
Okay, motion and a second. Roll call.
Kim, you're on mute.
Kim, you're in mute.
Okay, sorry about that.
Okay.
Okay, so let's see. Miss Rich,
No.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Mrs. Turner,
Yes.
Mr. Abowski.
Yes. Okay, thank you. I believe you have 2 years or so to get this accomplished. Good luck with the county.
Thank you.
Thank you very much.
You're welcome. Okay, so we are going to go to approval of minutes, June 24th, 2020, regular meeting. Do we have a motion to approve?
Motion to approve?
We have a second.
Second.
Roll call.
Miss Rich,
Yes.
Mr. Eisner,
Yes.
Mr. Burris,
Yes.
Miss Turner,
Yes.
Mr. Abowski.
Yes. Okay, so we're going to staff comments,
No comments.
board comments.
Oh, did you want to hear from me?
Oh, hang on.
Shocking.
We will get to the two of you, but we have two members. If Patricia could, or someone who knows these two people could introduce them, and then we'll hear from them first.
Okay, I can start with Mr. Steve Davis. He's our first alternate, new first alternate. And I will say that Mr. Bolton did submit his resignation and was sad to serve for a short time on the board and appreciated everything, but he could no longer serve. So Mr. Steve Davis is our first alternate.
First alternate.
Welcome.
Can you hear us?
Thank you.
Hi, Steve.
So does that mean, before you introduce yourself, sir, does that mean that Miss Rich has been moved up to regular, or they have to vote on that?
I'm sorry, yes, they did vote on it, and Miss Rich is now a regular member.
Congratulations.
Fantastic.
Okay, so Mr. Davis, please tell us something about yourself.
Well, I've been coming to Tarpon Springs. My mother lived here for 45 years. Been visiting down here for many years, 45 years. I moved back down here from Ohio. I'm a transportation broker, licensed broker. I retired about 3 or 4 weeks ago. I had an opportunity to move to Tarpon about 3 years ago. I live on one of the bayous, actually, so this really, I live in Kramer, so this really interests me.
Fantastic. Well, welcome aboard.
Thank you very much.
For your participation. And who is our other?
And our second alternate is Joanne Simon, who's with us.
And would you please tell us about yourself, Joanne?
Hello. I've lived in Tarpon since about 1998. My husband and I are very familiar with planning and zoning because we just finished building our house last year. So it's definitely an interesting experience.
Yes, you know how the sausage is made.
But we're familiar with the variances.
That's very good. Very
Yes.
good. All right, fantastic. Well, welcome aboard. Thank you for helping out. I know Mr. Eisner is bursting at the seams, so what do you got, man?
Well, excuse me, but I think I was in the first Citizens Academy class with Mr. Eisner.
Oh, boy.
I deny anything you have to say, so.
Oh, I don't know. I think I might have pictures.
Very well.
Well, thankfully, I was in that class as well, so thankfully you didn't remember me, but I know you cannot forget Mr. Eisner because to know him is to love him.
Well, thank you. I appreciate that. Now all I have to do is get my wife to think the same way.
Good luck.
So let me go into, I read all of the documentation that was in here. And honestly, I found it very hard to believe that, first of all, I know this is outside our realm, but a tree that's growing on top of somebody else's property, whatever is growing in the airspace is their business to deal with, not anybody else's. If the tree falls on someone's property, it's also theirs to remove. It is not where the roots are, it's where the tree falls. So everything that's on their property is theirs to deal with. So I couldn't understand where that came from at all, even though that's not what we were here to discuss. But it was all provided in evidence, so I kind of had to ask those questions. As far as the dockage goes, I was by there this morning and I couldn't believe, you know, they have a beautiful home there. It's a really small area. It's the smallest actual footprint of dock space of anywhere on that bayou. So, I mean, they're very limited to where they could put it. So I'm glad that we, as a board, approved and gave them the ability to enjoy Tarpon Springs like the rest of us enjoy Tarpon Springs. So welcome to our new members and welcome to your new dock to be built as long as the county approves. And, I'm done spilling over my joy for the day.
Thank you.
Thank you.
Jackie, did you have something?
Surprisingly, no, just welcome to Mr. Davis and Ms. Simpson, and wonderful that Ms. Rich is now permanent official. So I think we've got a great group.
All right.
Thank you very much.
Do we happen to know if we have another meeting next month yet?
We do. We have at least one case for September 30th.
Okay, well then we will see each other in a month. Thank you all very much. We're going to adjourn.
Stay safe.
8 p.m. Good night.
Good night.
Care.
Good night, all.